Welcome back to The Truth About the Market. I'm your host, Jason Zilberbrand. I'm president of VREF. I've appraised nearly every type of aircraft out there. My clients range from private owners to lenders, insurance companies, well-known operators, Fortune 500 businesses, law firms, government agencies, including tax assessors, as well as the FAA. And I've owned aircraft, operated aircraft. I've even bought them and sold them and financed them. And I've spent decades watching how this market behaves when conditions change. So when I talk about the aircraft market, it's not theory. It's definitely not social media commentary. It is, however, real-world transactional experience. Something else I want to mention, this podcast has no sponsors. We have no advertisers, no outside influence, and that means that nobody pays for my opinions. And that also means that nobody dictates my conclusions. Because aviation is a capital-intensive industry, mistakes can be extraordinarily expensive, and I've spent decades appraising aircraft involved in bankruptcies, partnership disputes, divorces, insurance claims, lender repossessions, estates, commercial litigation, and the one thing I've learned is that some of the largest losses in aviation have nothing to do with flying the aircraft. And today's episode is based on a real legal case in which I served as an expert witness. And to respect privacy and focus on the lessons rather than the individuals involved, certain names and details have been omitted or redacted. The facts, however, are drawn from court filings, my testimony, and the underlying transaction itself. And at first glance, this appeared to be a rather routine aircraft deal. It involved a purchaser entering into an agreement to acquire a late-model business jet for approximately $4 million. The aircraft involved a temporary lease structure, a planned transfer of ownership, and a path that seemed very clear to everyone involved. But it didn't stay that way. What followed was a series of events that transformed a rather straightforward aircraft acquisition into years of litigation involving disputed agreements, competing interpretations of contractual obligations, the sale of the aircraft to a third party, and ultimately the involvement of an estate after the purchaser passed away. Most aircraft transactions are forgotten shortly after they close. Funds are transferred, the title will change hands, and the parties move on, and it's usually just like that. Very simple, very straightforward. This transaction, though, it became the opposite. It evolved into a courtroom battle over ownership rights, sale proceeds, and a fundamental question that would eventually be argued before a judge and a jury. When does a deal become a deal? This transaction followed a very different path. So let me walk you through what happened. In 2018, a lease purchase agreement was executed for a late model light jet, a Honda jet. And under the agreement, nearly $4 million was paid in exchange for the right to operate the aircraft during a short lease period. And then after that, title, ownership, and possession were expected to transfer to the purchaser. But the transfer never happened. Instead, as the deadline approached, discussion shifted toward a different solution. Rather than completing the transfer, the parties began discussing the sale of the aircraft to a third party. Correspondence produced during subsequent litigation suggests there was an understanding that the aircraft would be sold and that the net proceeds from that sale would be distributed to the purchaser after deducting an agreed-to transaction fee, in other words, a commission. The aircraft was ultimately sold to a third party, but what happened next became the center of dispute. One side maintained that additional documentation was required before any proceeds could be released. The other maintained that the agreement had already been reached and that the funds were owed regardless of whether further paperwork was executed. See, this disagreement grew from a transactional issue into a multi-million-dollar lawsuit involving contract interpretation, ownership rights, aircraft sales practices, and the administration of an estate following the purchaser's death. What began as a routine aircraft transaction became a case study in how ambiguity can transform a completed sale and take it into years of litigation. So let's talk about the purchase. The dispute began with what appeared to be a relatively straightforward deal. In March 2018, a lease purchase agreement was executed for a 2017 Honda jet, and under the terms of the agreement, approximately $4 million were paid for the aircraft, and rather than immediately transferring the title, the parties agreed to a temporary lease period of 90 days, after which ownership, title, and possession of the aircraft were expected to transfer to the purchaser. Well, at first glance, the structure may seem unusual. In reality, arrangements like this are not that uncommon in business aviation, particularly when international ownership issues are involved. Aircraft transactions frequently encounter complications related to citizenship requirements, registration eligibility, how your trust is structured, how those taxes are paid, how it's going to be financed, and in this particular case, operational logistics. And in many cases, temporary ownership or leasing arrangements are used to bridge the gap between delivery and a final title transfer. And according to the transaction documents, the purchaser was granted immediate use of the aircraft while the parties worked out how they were going to do this transfer. The expectation was that once the lease period concluded and the necessary requirements were satisfied, title would pass and the transaction would be complete. Had that occurred, this aircraft would likely have become just another routine deal. Instead, as the scheduled transfer date approached, circumstances began to change. Discussions that initially centered on completing the ownership transfer gradually shifted towards alternative solutions. What began as a conventional lease purchase would eventually evolve into a far more complicated series of events involving a proposed resale of the aircraft to a third party, disputed contractual obligations, and years of litigation over the rights of the parties involved. And at this stage, nothing suggested a transaction was headed for trouble. However, the first problem approaches as the 90-day lease period neared its conclusion. The transaction encountered a hurdle that is familiar to many attorneys, escrow agents, and aircraft owners. The purchaser was not a U.S. citizen. While aircraft ownership by foreign individuals is common, the FAA registration rules impose specific requirements regarding who may directly register and hold title to a U.S. registered aircraft. And as a result of that, transactions involving foreign purchasers often require additional planning, including the use of non-citizen trusts or other ownership structures designed to comply with federal regulations. On its face, there was nothing extraordinary about this situation. Thousands of aircraft operate under trust arrangements, and the aviation industry has developed well-established procedures to facilitate these deals. The issue was not whether ownership could be transferred. Rather, it was determining the mechanism through which the transfer would occur. So here's what happened next. Because the transaction began to diverge from a typical aircraft closing, and this is according to the pleadings and correspondence referenced throughout the litigation, discussions shifted away from completing the deal, the anticipated title transfer, and it really moved toward a different proposal entirely. So this is what happened. The seller advised that the potential buyers for the aircraft existed and raised the possibility of selling the aircraft to a third party rather than transferring ownership to the original purchaser. The purchaser, who had already paid for the aircraft under the lease purchase agreement, allegedly agreed to explore that alternative. The concept appeared very straightforward. Instead of taking title to the plane, the person who bought the plane would allow the aircraft to be marketed, resold, and then those proceeds would be distributed pursuant to the agreement between the parties. And at the time, it likely appeared to be a practical solution. It was getting very difficult for this foreign owner to take delivery of this aircraft and own it outright. In hindsight, it marked the beginning of the dispute. This episode is powered by VREF, the standard in aircraft valuation. If you're buying, selling, financing, or if you're just trying to understand what your aircraft is really worth in this market, VREF it. VREF Online gives you the data that actually drives decisions, not opinions, not listings, not guesswork. So if you go to vref.com and VREF it before you make the call, it'll be the best thing you do. I promise you we'll save you money. Okay, let's talk about what happens next, because this is where things start to get really crazy. The aircraft gets sold. So by the fall of 2018, this Honda Jet had moved well beyond its original structure. What began as a lease purchase agreement had evolved into an effort to sell the aircraft to now somebody else. So according to the emails referenced in the litigation, the seller identified a prospective buyer and continued discussions with the purchaser regarding pricing, offers, and the expected proceeds from a sale. Communication between the buyers indicated that a transaction generating approximately $3.1 million net in proceeds to the purchaser was discussed and then ultimately approved. From a business perspective, the agreement seemed pretty straightforward. The purchaser was not going to take title. They would then sell the airplane to a third party. The aircraft would then close, and the agreed to proceeds of $3.1 million would be distributed based on what the parties agreed to, right? There'd be a commission to the selling broker, and there'd be the balance paid to the person who was supposed to buy it originally. The aircraft was eventually sold. Ordinarily, that would have marked the end of the story. But instead, the closing became the beginning of the dispute. Following the sale, disagreements emerged regarding the documentation required before the funds could be released. Draft agreements were circulated that sought to formally memorialize the agreement and included additional provisions addressing matters such as releases and indemnification, confidentiality, and other legal protections, pretty customary in this industry. The seller maintained that execution of these documents was required before any proceeds could be dispersed. The purchaser's position was that the parties had already reached an agreement and that the sale proceeds were owed regardless of whether further paperwork was signed or not. The focus of the transaction shifted immediately. The aircraft had already been sold. The buyer had already been found. The transaction had already been closed. The central question was no longer about the Honda jet. It was whether the parties had already made an enforceable deal. This is the most dangerous place to be in aviation, folks. When people talk about risk, this is what they're talking about. They usually focus on obvious things like mechanical failures, pilot error, fuel exhaustion, but the real hazards are things like what I'm talking about now, right? Because these are so important to the deal. The risks that emerge during aircraft transactions, they can be completely different. They're rarely going to announce themselves. And they develop quietly through assumptions, misunderstandings, and conversations that never make their way into any sort of formal documentation, let alone a purchase agreement. And in my experience, the most dangerous place in any aircraft transaction is that gap between what the parties intended and what they actually documented. One side believes a deal's been reached, the other believes additional conditions remain. One party views an email as a confirmation, the other views it as a step in an ongoing negotiation. Everything appears aligned until a disagreement arises, money becomes involved, circumstances change, and then every word by everybody is scrutinized because every word matters. Every email is going to get reviewed. Every draft agreement is scrutinized. Every conversation is going to be analyzed through the lens of hindsight. And at that point, the aircraft itself often becomes secondary. The dispute is no longer about performance, maintenance, market value, even operations. Instead, it becomes a question of obligations, expectations, and whether the parties truly reach the same understanding. That is precisely why aviation transactions require clarity, and not just at the beginning, but at every stage. The larger the deal, the more important that clarity becomes. Aviation history is filled with aircraft accidents caused by small misunderstandings that went unnoticed until it was too late. The same principle applies to aircraft transactions. When expectations are not documented with precision, the disagreement may remain invisible for months. By the time it surfaces, the aircraft may already be sold. The money may have already been moved, and the cost of resolving the dispute may far exceed the cost of the aircraft itself. So, if you're looking at an aircraft and wondering, what is this thing actually worth? Well, don't guess. VREF it. VREF Online gives you real-time data. We give you quarterly updates. We give you coverage across more than 900 aircraft models built on how the market actually behaves, not how it's advertised. Guys, this is the platform that every lender, every insurance company, every serious operator relies on when the number has to hold up. So go to vref.com and VREF it before you make a decision to buy or sell your next airplane. So you won't believe what happens next because the unthinkable happens. By late 2018, this dispute remained unresolved. And just to recap, the aircraft had been sold, the proceeds remained contested, attorneys had become involved, positions had hardened, and what had once been a business transaction was increasingly becoming litigation. Then in January 2019, an event occurred to change the trajectory of the case entirely. The person who was supposed to buy the aircraft originally died unexpectedly. And at that moment, The dispute ceased to be a disagreement between two parties attempting to resolve a transaction. It now became an estate matter. See, when a party to a transaction dies, everything becomes more complicated. The individual who participated in the negotiations is no longer available to explain his understanding of the agreement. No questions. We can't ask him anything, right? Questions that should have been answered through a phone call or meeting suddenly become matters of interpretation. The record is frozen in time. So instead, the focus shifts to the evidence. Trustees, estate reps, attorneys, and eventually the courts must reconstruct events using the documents that remain behind, which generally are emails, text messages, those draft agreements, all the correspondence between the parties, and transaction records. They all become critical pieces of the story. Every communication is examined. Every timeline is scrutinized. Every statement is evaluated for what it may reveal about the party's intentions. What makes cases like this particularly difficult is that the people rarely document every assumption they make during negotiations. Business relationships often operate on a combination of written agreements, a lot of verbal discussions, and then mutual understandings as to what developed over time. But after a death, those understandings can no longer be clarified by the person who held them. The question is no longer what the parties intended when they were negotiating. The question becomes what can be established through surviving evidence, and those two things are not always the same. So, let's talk about what this case teaches aircraft owners, because after more than 3 decades in aviation, one lesson has remained remarkably consistent. Aircraft transactions rarely fail because of the airplane. They fail because expectations, obligations, and ownership rights become unclear. I've reviewed transactions involving everything from piston aircraft to large business jets. I've appraised aircraft in bankruptcies, estate disputes, divorces, lender repossessions, fraud investigations, and commercial litigation. In nearly every case, the underlying dispute can be traced back to one common issue. Someone believed the deal meant one thing, while someone else believed it meant something entirely different. It really is that simple. And this case is a perfect example of that. The dispute was not about the condition of the plane. It was not about the price. It was not about whether a buyer existed. The disagreement centered on who was entitled to what under which agreement and under what conditions. You know, for aircraft owners, buyers, brokers, lenders, the lessons are very straightforward. Know precisely when title transfers. Know exactly what rights exist before that happens. If a transaction changes course, document the new arrangement and do it with the same level of detail as the one you did originally. And if an aircraft is being sold on behalf of another party, how about clearly defining who receives the proceeds, when those proceeds will be distributed, and under what conditions must be satisfied before the payment can be dispersed? But most importantly, ensure that all parties share the same understanding before the aircraft is even sold in the first place, before the funds are even transferred. Because once an aircraft changes hands, the negotiating leverage changes. Once proceeds are received, leverage changes again. And if a dispute remains unresolved long enough for illness, incapacity, or death to enter the picture, a business transaction can quickly become years of expensive litigation. Clarity may not prevent every dispute, but ambiguity almost guarantees one. So this is my final thought. When most people think about risk in aviation, they think about what happens in the air. They think about whether systems are going to function, or if there's going to be a mechanical failure, or whether or not the pilot making decisions knows what he's doing, or if there's going to be a runway excursion or an engine problem. Those risks are super visible. They're tangible. They're studied. They're measured. We insure against them. And we discuss them all the time. The risks that arise during aircraft transactions, though, they get no attention. Yet some of the largest financial losses I've ever encountered during my career had nothing to do with flying. They occurred in conference rooms. They occurred in email chains. They occurred during negotiations that seemed routine at the time. The aircraft at the center of the dispute never suffered an accident. There wasn't a structural failure. There wasn't a maintenance event. No insurance claim arising from the operation of the aircraft itself. Instead, the dispute grew out of a transaction that evolved over time, that changed direction and ultimately became the subject of competing interpretations regarding aircraft ownership rights, and then contractual obligations, and the distribution of millions of dollars in sales proceeds. This is what makes this case so instructive. It serves as a reminder that transaction risk is real risk. The same attention owners devote to maintenance records, title searches, pre-buys, and operational safety should also be voted to documenting agreements, clarifying expectations, and defining ownership rights. Those details often seem unimportant when everyone is cooperating. They become critically important when circumstances change, because aviation is built on precision, and the most successful transactions are as well. And because sometimes the most expensive loss in aviation is not caused by an incident or a storm or a mechanical failure, sometimes it begins with a misunderstanding that grows into a dispute and ends in a courtroom. If you found value in today's discussion, please share this episode with a fellow aircraft owner or buyer or lender or a broker or even an attorney or anyone involved in an aircraft transaction. These conversations help bring transparency to an industry where the stakes are often measured in millions of dollars. And if you enjoy the content, please subscribe, please follow us, please give us a rating, review the podcast. Your support helps us continue producing independent market analysis and ensures that these conversations reach a broader audience. Most importantly, please share the episode. The best discussions in aviation start when professionals exchange ideas, when they challenge assumptions, and learn from experiences of others. And remember, VREF, the Truth About the Aviation Market podcast, exists for a single purpose: to help owners, lenders, insurance companies, attorneys, aviation professionals, to help all of you make better decisions through objective analysis of an aircraft as a financial asset, not as sales inventory, not as marketing material, not as a manufacturer talking point. Instead, as a real-world asset whose value is shaped by economics, risk, liquidity, operating costs, technology, and market demand. Because understanding what an aircraft is worth is important. Understanding why it's worth that amount is where the real insight begins. Lastly, when you need accurate, defensible, data-driven aircraft values, there's only one name in the industry to trust. That's VREF. Go to vref.com to get started today. I want to thank you for listening. I'm Jason Zilberbrand, and this is The Truth About the Market. Until next time, fly safe and stay smart.